Great. Everyone, welcome to the second day of everything you need to know about Section 230 in 5 hours, which, as I pointed out yesterday, I was fact-checked on by Eric Goldman's son. That that is in fact 7.5 hours. I was hoping no one would notice, so I could get away with my catchy title. But yes, it is in fact 7.5 hours of talking about Section 230, and the 5-day series is really designed to kind of be a holistic look at the law itself, its history, how it applies to telecom and agencies, how it's been interpreted by platforms, and then kind of a current event, 2 days of current events and future, and then looking forward about why we're talking about Section 230 so much right now, and where we're going in the future if we don't have the protections that Section 230 provides. So yesterday we had the history section. It was Jeff Kosef, Eric Goldman, and Marianne Franks. And today we have what 230 meant and means for telecom and agencies. And we're joined by Blake Reid, clinical professor at the University of Colorado Law School, Olivier Sylvain, professor of law at Fordham University Law School, Tejas Narechania, assistant professor of law at Berkeley Law School. And so we're really thrilled. Olivier, Tejas, and Blake are the leading experts, honestly, in Section 230 and what it means for telecom. We're going to spend a little bit of time expanding on what it means outside the FCC, but we are so lucky to have you three here. Thank you for joining us.
Glad to be here.
A few quick kind of top of the hour things. One, we're going to say ISP a lot probably today, and this is hosted by the Yale ISP. That's the Information Society Project. When everyone else refers to it, this is going to be probably referring to the information service providers and not the Yale affiliate. And then for Q&A, what we're going to do is put your questions in. If you have questions and you want to ask them, I will rapture you in to ask your question in the second half of the show at around 12:45 or 12:50. So put those in the Q&A. I cannot manage chat and Q&A, so don't chat at me or anything, or raise your hand. We'll just split about 45 minutes of chatting with the four of us and then 45 minutes of Q&A. This is being recorded and it will be posted both in the Yale ISP website and at Lawfare. And we have just learned that we're going to have it turned into a podcast. And so I am excited about that. So yesterday, to get into it, yesterday we spent the day kind of talking mostly about harms on the internet and the intermediary liability immunity that Section 230 provides, and that was primarily comes from Section C of Section 230. Today, we're going to kind of talk about some of the broader policy implications from the rest of Section 230. And I was just going to point out that I have this is the weakest area that I have knowledge that I have about Section 230. And so I will be kind of figuring out some of these things right along with everyone else. I think that a lot of people, you can talk about Section 230 in two different ways. And this is sometimes where you'll have one conversation happening here and another conversation happening here, or just going past each other because someone's talking about Section C and intermediary liability, and someone else is talking about the power to regulate the internet. And so with that, Blake Reid has a tremendously useful walkthrough of the latter understanding of Section 230. And so Blake, do you want to get us started kind of on what we mean when we're talking about administrative agencies in Section 230 and why these things are interrelated?
Yeah, I'll give a couple of quick cuts and then turn it over to Olivier and Tejas to fill in. It's important when we think about Section 230. So a lot of people think of Section 230 of the Communications Decency Act, but really the Communications Decency Act was a smaller part of a much broader law, which is the Telecommunications Act of 1996. That's a big deal for telecom law folks, because the last time the communications law or the telecommunications law was amended was 1934. We still have the Communications Act of 1934 as amended is like our home statute. And the 96 Act was the last time it was updated in a significant way. And it's important to know that when we say Section 230, we're talking about part of the Telecom Act, so and part of the Communications Act. So it stands to reason that the FCC is going to take a really hard look at all of the statutes under its control, because the FCC is charged broadly with administering the Communications Act, and Section 230 is a part of it. And maybe just the last thing I'll say at the front end here is the 96 Act came out right before the internet was a thing, right? I mean, it was the worst timing ever. It's kind of 5 or 6 years of fighting and trying to compromise on all this stuff that would bear on internet policy, right? Like internet policy was about to become a big concern, but there's almost no reference in the act to the internet itself. And one exception to that is Section 230. And so Section 230 is this like source of illumination for the FCC as it's thinking about all these brand new internet policy problems. The rest of the act doesn't really say much about it. And so the FCC for the last 20 years has looked to Section 230 for guidance about how it ought to discharge all of its other responsibilities.
Thank you guys. One of those things, I've been doing this for 3 months and I'm still, it still happens. One of these things that I think is so counterintuitive to Section 230 is specifically that it was seen as a tool for deregulation by agencies. I kind of think of agencies as being about regulation, and maybe that is like a very overly simplistic way of thinking about it. But does either Tejas or Olivier, do you guys want to speak to that a little bit and how it's been seen? It's been seen as a deregulatory tool of the FCC?
I can. I mean, I'm happy to jump in here, Tejas, if you don't mind. And I want to say a couple things. First, thanks for having me and joining this group. You said that you included me in a list of people who are leaders and scholars of 230, and you've assembled a great group of folks this week, and so I think we can all appreciate that there are many people who are now thinking about this, and it's due. On your question, it's really interesting because 230 is as Blake says, part of a reform that includes obscenity reform, right? So the Communications Decency Act actually has amendments like that are addressed to obscenity online, right? So you know, conservative and I think some Democratic Congress people in 1996, and you probably took this up yesterday, were concerned about the proliferation of quote unquote objectionable content, and they were worried about porn. And 230 doesn't fit easily. This deregulatory conception of 230 does not fit easily with a reform that actually does mean to regulate. As most of us know, the Supreme Court strikes down the obscenity provisions of the CDA, leaving 230 to stand. So I mean, and the agency has, the Federal Communications Commission has cited 230 for deregulatory sorts of interventions, which Blake's account actually does a really nice job on. But for what it's worth, I mean, you know, 230 was also invoked in the first adjudication involving network neutrality. Now that's a separate issue to regulate what I call ISPs, internet service providers, but you know, to regulate broadband service providers. So I think the story of whether 230 is deregulatory is not completely right. Like, I feel like it's a complicated story because it's been invoked by the agency to do different things, pro-regulatory and less regulatory. And it was also included with an ambition to regulate content on the internet.
Do you want to follow up on that? That's great.
Yeah. No, I mean, I don't think I have much to add there. I think, you know, it's interesting that 230B and the policies really seems to drive home this story. Now, whether it's accurate or not is probably a topic for a different day, but the story that the internet has thrived in the absence of regulation and because of the absence of regulation. But as Olivier said, 230 has in fact been invoked in a variety of circumstances, both to regulate in contexts where, in the net neutrality context, in contexts where the FCC is trying to impose additional requirements on parties trying to merge. So in the case of AOL and Time Warner, but also for deregulatory purposes too. So to sort of further this story that the internet doesn't need regulation, the internet can't survive with regulation, and 230 tells us that, and so we're going to undo some of the things that we've done in the past. So 230, in terms of just, is it a regulatory or a deregulatory statute, to the extent that those terms have meaning, isn't very clear. It could be read either way, and it has in fact been used in both ways.
And maybe just a quick two-finger add to say, one example of that, how do you treat this as regulatory or deregulatory, is all the preemption actions that the FCC takes. So it invokes 230 when it goes to the Minnesota Public Utilities Commission and says, hey, you can't regulate voice over IP, right? We're not going to allow this to fall within your jurisdiction because 230 tells us to have sort of a deregulatory policy about it. On the one hand, that's kind of deregulatory. On the other hand, it's reaching with a fairly heavy hand from Washington and saying, no, State Public Utilities Commission, you cannot do this. So I agree with Tejas that it's a complicated story, right? It's not easily amenable to that regulatory, deregulatory dichotomy.
Great. So kind of, if someone wants to start off with leading us kind of through the interpretation of the provisions. So just so everyone is clear, section 230A finds that Congress finds the following, and these are the main kind of provisions, is with that the internet and other interactive computer services have flourished the benefit of all Americans with a minimum of government regulation. And then in 230B, 2, it is the policy of the United States to preserve the vibrant and competitive free market that presently exists for the internet and other interactive computer services. And so this is just I'm just like reading that language because we spent most of yesterday talking kind of implicitly about 230C, which was about, again, intermediary liability for platforms that host material on the internet. And so this is kind of the other half of the act. So it's totally up to you guys which order you want to take this in, but I will defer to you about where you really want to kind of start. I mean, I'm happy to walk through the cases. I think that those would actually be helpful. If you feel like they're kind of, Blake, this paper is so great. I'm almost happy to walk through it as like an outline of how to talk about the history of the interpretation of parts A and B.
Well, can I suggest one framing device that we might follow, which is 230 interestingly refers to the internet, right? It uses the term the internet, which doesn't appear a lot of other places in the Communications Act. And it might be useful to complicate the conception of what the internet is, because I think the way that the FCC approaches, quote unquote, the internet is as a bunch of constituent parts or constituent layers, and it takes very different approaches to each of the layers. Is that cool if can we do the layer stack for like 2 seconds?
Layer stack is a great way to talk about it. Yeah.
Okay, so I'll take a stab at it, and then folks correct me if you disagree or I'm wrong about this, but the simplified idea of the layer stack is we take the physical layer, the network layer, the application layer, the content layer, and there's more of them than that, but those are the 4 important ones for this discussion. And the physical layer is like, we're gonna dig trenches in the street and run wires to you, or we're gonna license the transmission of wireless signals. And the FCC traditionally tolerated a lot of regulation at that level. Then there's the network layer, and this is the internet protocol, right? This is the language that all the applications on the internet, whether that's email or the web or instant messaging or Twitter or whatever else, use this language to communicate to each other so that you can be on different physical networks, right? You could be connected via wireless or Wi-Fi, or you could be on a fiber connection, or you could be on satellite or whatever. And it doesn't matter. We got this kind of common language. And that's been really contested, whether the FCC is going to do anything at that layer. And then we get the application layer, and this is all of the stuff that we experience, that we use, right? The web, email, Netflix, et cetera, right? And so the question, and then we've primarily understood Section 230 as giving us these Good Samaritan and publisher speaker immunities at the application layer. But that leaves all these really unresolved questions down at the physical layer and the network layer. And maybe it'd be useful to talk about how the FCC has used Section 230 in sort of traversing what it does at the physical layer, which is like, how do we deploy broadband? How do we actually get people access to the internet? And then how do we regulate the network layer, which is like, what are we going to allow internet service providers to do in terms of controlling what people do on the internet? I don't know if that's helpful for Olivier or Tejas to pick something up there.
Yeah, I think that's helpful. I mean, I want to complicate in ways I'm confident Blake would say more about if you weren't generous enough to open it up. But you know, in 2020, you know, we are at a point where the FCC itself has been wrestling with the integration of the physical infrastructural layer and the top layer, and it comes up pointedly in examples, without getting too technical, programs like zero rating or voice over IP even, right? Old sort of technologies where it's those. I think the framing that Blake has set out is exactly right and useful, and it's, you know, it's the kind of thing we hang our hats on as you know, telecom kind of people. But we, you know, this is an area that's been complicated over the course of time, to return to your the way you had originally set this up, Kate, talking about A and B and C under 230, Section B is the one that the agency has invoked loosely, not, I think, artfully, to justify physical layer interventions, right? So this deregulatory language is invoked through the knots and into the early 2010s to justify a couple different kinds of regulatory interventions. But I completely agree that the FCC's primary source of justification for intervention is under the interconnection requirements that are addressed at the physical layer, right? What we call under Title II and also Title III. And then it's hard to know what to do with 230 and the regulation of the network of the content and application layer.
Yeah. Do you have anything to add, Tejas?
No, I mean, I worry that anything I add would take us further down into the weeds and the rabbit hole. Yeah, Olivier is right to say that, you know, the FCC, Olivier and Blake are right to say that the FCC has traditionally been quite okay with regulation at the physical network layer. That the most important forms of FCC regulation today are probably forms of interconnection regulation. And that 230, you know, to the extent the FCC has invoked 230 in the past, and to the extent it's invoked it in internet-related contexts, it's done so when it comes to interconnection. So this is where I'm going to try to stay at a high level, but probably dive into a bit of regulatory detail. So if you remember,
let's do it.
If you remember dial-up internet,
I was going to try to make the sound for a second, but then decided that
I do play it for my students and see how many of them recognize it. So if you remember dial-up internet, right, the idea was that your computer would call an ISP. And there were a lot of pitched battles about if you were an AT&T subscriber and your ISP, say America Online, was a Verizon subscriber, an MCI subscriber, or as was often the case, a special phone company that was set up only to serve ISPs. There were a lot of really pitched battles about how your call from your modem would get handed off to the provider of America Online or CompuServe or Prodigy or NetZero or whoever. And how one phone provider would pay the other for the burden that's imposed on that telephone network. And 230 is invoked in all of these battles about how that compensation should be structured and who should pay whom and how much, and whether AOL and AOL's own specialized phone provider were taking advantage of the regulatory system then in place by basically collecting revenues every time someone called over to the ISP in a way that distorted the dial-up ISP market. So eventually the FCC, relying on 230, says you can't pay anything. And the reason we don't want to pay anything is because we're worried that the market for network access, the market for internet access services, is being distorted by our phone regulation. And in a way, you know, at a 50,000 foot level, the FCC's argument here is that there's too much internet. That internet is too subsidized and that there are too many people connecting in order to, and this is distorting the market, and it's problematic. And so what we're doing is deregulating this to normalize the market. And that's sort of an interesting that's an interesting argument when it's read against 230's language about a thriving internet and the importance of access. I'm not saying that the FCC was necessarily wrong or right. And again, I'm trying to avoid too much regulatory detail, but I do think it's sort of worth thinking about, you know, what the FCC was trying to accomplish and whether it was successful in doing so.
So let me tag on, if I can, with just one kind of framing point to link us to the bigger picture about 230, which is all of what Tejas is describing there is part of this policy set out in 1996, and this is like Clinton era market Democrats driving this thing, right? We've just come out of the AT&T breakup. AT&T has been dominating the communications ecosystem for the last, you know, however many decades, or, you know, more than, you know, close to a century. And we want to move into a world where we have competitive telecommunications access, right? And so all of these things, all these interconnection things, all these either meddling in the pricing schemes or not meddling in the pricing schemes, all these little details that are the province of poor telecom lawyers working down in the sub-basement of the FCC are trying to spur competition among ISPs that we don't get what happened with AT&T. They're also aimed at kind of disempowering ISPs on some level, right? Because what happened with AT&T was if you wanted to innovate, right? You wanted to add a wireless connection to your, you wanted a cordless phone at your house, right? You had to basically go ask AT&T's permission to do that, right? You wanted to mess with the phone book, you had to deal with AT&T. You wanted to do anything around the telephone network, you had to go through AT&T. And so we're trying to kind of disempower that a little bit and make sure that we had lots of competition for accessing the internet. And where 230 fits really nicely together, where it kind of bridges the discussion you guys had yesterday, the one we're having now, is this policy statement says, look, to have a really vibrant application layer of the internet, to have all of these interactive computer services that everybody relies on, we need to have competition at the physical layer, right? We need to have lots of different ways for people to connect to the internet so that we don't end up in a world where suddenly the internet service provider controls what happens at the application layer, right? We just were in that world with AT&T and we didn't like it. And so 230 is a nice way to bridge that. And you can kind of say, well, it's got this deregulatory idea. We want to empower the application layer platforms to do all the moderation that they want, to act, you know, to make the best judgments that they can. But on the other hand, we want to cast kind of a skeptical eye at the ISPs to make sure that we get competition at that layer so they don't kind of garner too much power. And so there's a way you could view 230 as kind of intermediating the relationship between ISPs and platforms. I don't know if that's a helpful way to think about it, but
no, that's a super helpful way. Go ahead, Olivier.
You know, I think it is, I don't know if it's generous or if it is, I'm not sure if 230 operates as a mediation or if it is Congress's assertion that we do not want the application layer to look anything like what this legacy infrastructure layer looks like. And so we're going to back off and we're going to try to make sure that we don't see monopolization. And so it is very much a creature of its time. I think you're exactly right. Like it's a creature of its time when people are especially worried about the big players in the infrastructure layer, and this is the answer. So I don't know, you know, I'm not going to quibble with the vocabulary, but it seems like a bolder assertion than a mediation, right? An intermediation. It seems like I mean, the language, the precatory language that Kate just read, I mean, it's pretty powerful, and it is the sort of thing that many strong advocates of the robust immunity today turn to.
And
Like you had highlighted, oh, go ahead, Tejas, please.
I was just going to add, I think that's exactly right, and I think it's of a part of the rest of the Telecommunications Act, and not to turn this into a net neutrality discussion, but what 230 does in deciding what sorts of regulation is appropriate at what layers, and in particular saying we don't want severe government interference, if it's called that, regulation at the application layer, is exactly the same as what Congress did in setting out the difference between, I think, telecommunication services and information services. And as it creates these two distinct statutory categories based on the Commission's own precedent. And so the Commission, even before the 96 Act, had set out basic services and enhanced services and had this distinction between the things that we are comfortable doing at the lower, closer to the physical layers, and the things that we don't want to do at the application layers. And so 230, the structure of the Telecommunications Act of 1996, I think altogether do exactly what Olivier and Blake said. They set out distinct modes of government regulation at different layers of the internet.
Yeah. Blake, yesterday we had Jeff Kosif on, as you know, author, probably knows more about the history of Section 230 and its drafting than anyone on the planet. But you had mentioned that you talked to him yesterday and that he had reminded you that a section had been removed from the act. Do you want to kind of talk about that a little bit and how that what that implies for the agency's interpretation?
Yeah, I'll tee that up, and then I know we also too want to talk about the executive order, so I'll try and blend both of these in a
Sure.
way that kind of gets us there, and maybe we can touch on net neutrality really briefly on the way. So there's actually this provision in that was struck from Section 230, Section 230D, which is now the exceptions, but the original Section 230D was prohibited or said nothing in this act shall be construed to grant any jurisdiction or authority to the Commission, meaning the FCC, with respect to economic or content regulation of the internet or other interactive computer services. So there's a really expressly deregulatory provision that sort of said, FCC hands off the application and content layers of the internet, don't mess with this at all. And that was struck. And so Jeff asked me, what would have been different if that provision had been in place? And so I guess where this really has cashed out, or where a lot of that fight has really cashed out, I think maybe we have to start talking about net neutrality, right? And the notion of net neutrality is the idea that, and this is going to sound familiar to folks who have been following 230 over the last couple of weeks and heard a lot about political discrimination and urging, the Trump White House is trying to impose some kind of political non-discrimination mandate on platforms like Twitter. Well, we've been having this fight for the better part of 50 years in telecommunications land about non-discrimination, right? And we had this fight on the internet when we talked about whether ISPs can do that kind of discrimination or any other kinds of discrimination. And so one of the big battles that the FCC has fought over, restricted to the last 20 years, is can we impose some non-discrimination obligation on internet service providers that says they cannot discriminate on the basis of application? So if you're using, Spotify instead of Apple Music, can they block Spotify but not Apple Music? If you're accessing some particular kind of content, maybe you're looking up websites that have a lot of political content that's favorable to Republicans but not Democrats, they can't block that. The ISP cannot block that. And so we've had this very pitched battle for, the better part of the last 20 years about whether the FCC has the authority to do that. And 230 is pretty interesting in that regard because on the one hand, 230 has got these immunities and it's got this Good Samaritan protection for application layer platforms. It says these guys can do all the discrimination they want. Right. But then on the other hand, it sort of contemplates that we've got to have that's got to have a foundation somewhere, right? It's got to have ISPs that are competitively serving people's traffic and empowering people to pick whatever platforms they want. So say your platform is not doing the kind of discrimination you want, you go to a different one. You don't like Twitter, you could go over to Gab or what have you. And so Section 230 has been variously cited by, and this is like a pendulum swing between Republican and Democratic administrations, to justify either imposing net neutrality regulations, right? So we've got the Obama era FCCs each pointing to 230 pretty favorably of the notion that they could say, ISPs don't get to do any kind of discrimination at all because we want to protect the vibrant sort of discrimination that happens at the application layer. And then we have Republican era FCCs. Well, there's sort of a complexity to this, but in general, the Republicans, the current Republican, have said, no, 230 says we don't regulate the internet at all. And by the internet, we mean not just those application layer platforms, but we also mean ISPs. We don't want to regulate what ISPs do. And we don't want to have the government meddling there. And so that's been kind of a big back and forth about 230 in the context of net neutrality. Does 230 support the notion of discrimination, or does it sort of say we don't want discrimination at the network layer? Sorry, I've been going a while. I'll shut up.
This is why actually, so it does help us get to the executive order.
I think that's actually perfect, Blake. Thank you. Go ahead, Olivier.
Yeah, and I don't think the language monopoly appears as much in the executive order as it's appeared in Attorney General Barr's mouth recently. But that is, I mean, if we were to sort out why the two would be treated differently. When I say the two, why the physical infrastructure layer could be treated differently in the top application content layers, because of a concern about, a market concern about the dominance of internet service providers, right? And their ability to control content that reaches users, especially if there are one or two or at most three internet service providers in any given area. And so when Barr and others invoke concerns associated with monopoly control, they're channeling that concern, and that is it's a colorable argument. I mean, we'll eventually get to the question of whether the FCC in fact has authority in 230, but as a policy argument, you know, one can envision coloring our conception about the distinction between the applications at the top and the infrastructure at the bottom, if the applications on top, in fact, operate something like monopolies. And, you know, in truth, in my mind, there really are two or three dominant in this category, right? Maybe Google and Facebook. You know, we can talk about the big five generally, maybe. But have they crossed the threshold, right, to look like something that is otherwise within the category of Title II regulation, or within the category of what we might call monopoly, or what then Judge Kavanaugh in the DC Circuit and conservative judges in the network neutrality setting was invoking, right? So I would offer that as a way to think about the executive order. I frankly I think that's a disingenuous argument, as articulated here, especially because. And I don't know if you want to go that fast into the executive order before hitting the I's, crossing the T's and dotting the I's, but I do think that that's at work here. Yeah,
I had a similar sort of question about, you know, as you said, let's put to one side the question of FCC authority and ask whether or not this is what the executive order is trying to do is actually good policy. And, you know, there are, like you said, there are maybe a handful of application level services that Twitter, Facebook, that have substantial power, if not technically market power. I think that's an open question. It's one that's subject to debate. So is there really a problem here that's worth some sort of regulatory attention? And I think, you know, typically we would think of the monopoly power or the potential acquisition of monopoly power as potentially problematic. But then you also have to think about what the right solution is to that. And it's not clear to me that the executive order has the right solution either. So even if I were to grant, right, go even further than Olivier does and say, look, Facebook and Twitter have market power, they're monopolies, or they have monopoly power, and that we ought to regulate them. Our traditional approach to that sort of problem in these First Amendment adjacent spaces has been things like competition like solves. So whether it's direct competition, limits on market size, limits on the user base, those are the types of solutions that we have traditionally tried to impose on these providers because they offer some objective neutral criteria that more or less keeps government out of directly choosing winners and losers, directly choosing what sort of, if you take down this sort of speech, it's good faith. If you don't take down this sort of speech, it's not good faith. And I think the executive order here, depending on how you read it, doesn't do that, right? It is much closer to direct regulation of speech in a way that telecommunications regulation has tried to avoid for a very long time.
I just want to quickly, Blake, I want to go to you, but I just want to quickly add, so we don't forget to talk about it, which is that when we were pre-game showing, Olivier brought up the fact that the executive order and that 230 applied to more than just the FCC, and that there were 8 other administrative agencies involved and implied. And so I just want to also just hit, I think that loops into this conversation. So I just want to flag that as something to come back to, but Blake, go ahead.
Yeah, let me pick that up and tie to what Tejas just said, which is, so there's sort of 2 questions here. There's the regulatory buckets, and we're worried about the concentration of power in these different regulatory buckets or different regulatory levels. And then there's the what do we do about it? And the executive order is primarily focused on the what do we do about it question. And Tejas did a nice job explaining what it asks the FCC to do, although I think he's being a little bit too polite. I think what the order asks the FCC to do is just sheer nonsense, right? There's a good discussion, I think, on the Vergecast the other day that goes through it's like this galaxy brain reasoning for how it imposes, or how it would interpret the good faith requirement of Section 230 to require some relationship between how you enforce your terms of service and what you actually do on moderation policies, and somehow that's supposed to lead to some world of political neutrality. I don't think that's even worth spending that much time talking about, because it you just have to buy into almost all these kind of conspiracy theories to make it make any sense. I think so too at the FTC. The remedy is pretty nonsensical, right? It's let's use the FTC, which has this general authority to pursue unfair and deceptive trade practices by internet businesses, and let's somehow ramp up if a platform promises something in their terms of service and the rules, and then they act in some different way, then the FTC can somehow generate a case out of that. Without getting too deep into the weeds there, I think that is likewise pretty nonsensical and pretty at odds with the FTC's precedent in adjudicating those kind of cases. But I do think the really interesting question, and Olivier put it in such a nice way, is this is a question about where power is concentrated in the layer stack of the internet, right? And the conception that 230 had back in 1996 was, we are really worried about internet service providers having a lot of power. These guys are going to be the new AT&T. In some cases, it's just the old AT&T, literally, right? They're going to have a lot of power, and all these new little platforms, the Prodigies and the CompuServes, but the little bulletin boards and the Usenets and everything else that was kind of the proto internet, all that's happening at the same time. And those guys have no power at all, right? That might not even get off the ground. It'd be cool if it got off the ground, but it won't. And so we've got this kind of pyramid structure, right? Where it's tons of power down here, little tiny bit of power up here. And I think the conception that Barr and the White House and Republicans in Congress have successfully leveraged is that pyramid's starting to look more like this, right? And to bring it back to the FCC has really enabled that, because the Republican FCC commissioners have all, in trying not to check power at the ISPs, have over the years engaged with a lot of kind of footsie with an argument that says, actually, the real problem isn't ISPs, it's Twitter, it's Facebook. Really, it's not even it's like an inverted pyramid. All the real power is up here. And now they're going to be on the hook for delivering on that, or to sort of go back to some principles and not deliver on that as the executive order gets rolling and NTIA petitions for them to do something with it.
I mean, the way that the Republican conception of this years ago has been asserted the past decade is very much a kind of inverted pyramid conception, but it's the argument is that Google is extracting rents from the service providers and not paying for the service that these carriers are providing. And I mean, that's the gist of it, that they're kind of free riding. I want to, just in case it wasn't clear, I also want to actually interrogate the galaxy brain argument that is in the executive order. I just want, please let me do this also.
Fine, do it.
Yeah, I won't do it for long. There are a couple of things I want to say about it on this. I mean, I think, Blake, you were being too kind, even. So Tejas was being too kind. I think you were being too kind. It's lunacy to
sorry.
the White House, through an executive order, make the Commerce Department, through the NTIA, make a recommendation to the FCC, an independent agency, to intervene in an area that most people think the FCC has not had historical authority over. That's crazy. Like it's a sign of impotence, and I don't use that word lightly in the context of this presidency, but it suggests a kind of a complete baffled understanding of how the administrative state. So that said, the FTC, as Blake has already observed, is relevant here. And just to be plain, what's kind of bizarre about the executive order is that the FTC has already been in the business of interpreting the Section 230 in the context of litigation in furtherance of its Section 5 power, right? So as Blake says, it has the power to enforce and protect against unfair trade practices and deceptive trade practices. And they did it in a case involving AccuSearch, which actually is invoked telecom law, but they argued that AccuSearch, a company, was unlawfully drawing on illegally distributing or publishing, I'd say, private information in violation of the Telecom Act. And it did it in the lead click case, and in both cases, it had to navigate the 230 immunity and did so successfully. So it's not like the executive order is broadcasting any news with regards to what the FTC might be able to do. Now, the one thing I will add on the FCC's authority here, I'm very skeptical also about the FCC's authority to regulate in this space. But I will say that the FCC does have the authority to regulate good faith questions. And telecom lawyers know when they do have it, and that is in the context of retransmission.
Wait, you mean good faith, not like the statutory term, but like good faith in the general sense?
No, in the statutory sense. So under Section 325, that the provision is addressed to cable retransmission of broadcast signals. The reason that the FCC has argued that broadcasters, neither broadcasters or cable companies, can black out each other, right? That they have to negotiate in good faith. And there are regulations that set that out. But guess what? Section 325 asserts that the FCC has the authority to do it, right? It explicitly says they have the authority to promulgate regulations. So this does return me to Blake, your invocation of Jeff's argument about what was omitted from 230. Maybe this would be a more interesting, maybe it is more interesting now than it would have been had that provision been included. But just to be clear, that authority under 325 to regulate in good faith is paired with a regulatory authority to promulgate regulations.
Well, Tejas, I want to get one really quickly. I just want to say that there are a few people here that were part of, I think, the 230 hearing, or like the informational hearing that the DOJ held in February, and I was part of that, and it was batshit, to put it like mildly, and so I wasn't surprised by the executive order. But if anyone would like to kind of give their take on that, and raise their hand or do whatever that wants to speak to like their take on what was discussed. It was such a messy day. Of talking about this, about Section 230, that it was exactly what Olivier basically just said, which was just like, it just didn't parse. It felt like the whole day felt like a parse error. Like, it was just like, not like things were not making sense. So, but anyways, Blake, I think the gauntlet has been thrown on the executive order, so please feel free.
Well, yeah. So let me pick up where Olivier left off with this good faith provision, because the FCC has the good faith regime that he described. There's also this language, good faith, in Section 230, which is what the executive order is asking the FCC to litigate or to opine on. And I think there is enough there that while the whole idea, I mean, geez, if you look at Republican Party orthodoxy in terms of, the FCC regulating the internet, that was like a fear of what the Democrats were going to do 20 years ago, right? Like the notion that the Democrats would try to crawl up the stack. That was like the worst nightmare of every Republican telecom consultant for like 20 years. So to suddenly see a Republican president on the other side of it is just wild. But because it's so wild, it actually, there's all of these little tools that have never really been explored. And suddenly we're going through this, like, we actually have to look, does the FCC have the authority to do this? And this is pretty classic Trump, right? Like, so Trump is the greatest gift to telecom law professors ever, because everything he says about telecom law is just a ready-made exam question. So he says stuff like, my favorite Trump tweet of all time is, he says, net neutrality is the fairness doctrine for the internet, right? Which for someone really steeped in telecom law, you're like, no, like that's not right. It doesn't parse. Like you're missing all this detail. But you try to explain to someone why that's wrong, and you end up like 4 hours later, and you end up like the Always Sunny guy with like the conspiracy whiteboard trying to explain it. And so he has these ways of telling these kind of lies about telecom law that have enough of a veneer of truth that disproving them is really, really, really hard. And so as Olivier points out, like we're going to end up, if the NTIA, as they're reported to do, files this petition with the FCC, and all the Republican FCC commissioners have evinced at least some willingness to entertain it seriously, and some fairly seriously, we're going to spend the next 6 months at least, and if Trump is reelected, longer than that, going through the machinations of actually analyzing all these questions. We're all going to be filing comments at the FCC. There's going to be endless litigation about it. We're going to spend the next 3 years on this question that all of us know at heart. Am I allowed to say bullshit? Like, we all know this is bullshit, right? But we're going to spend the next 3 years on it if we don't get lucky, right? And so there's something there, right? And the lawyers at the White House are probably a little bit smarter on this than we want to give them credit for.
Hey, Juice.
So let me pick up on that, on sort of the arguments that the NTIA lawyers or the FCC lawyers might try to make. Let me also echo Olivier and Blake and sort of saying, look, like my priors tend to favor agency power. Like I'm a fan of deference and agency power and technocrats exercising their expertise.
Call it the deep state.
But I think
this is a false flag operation to make you doubt your priors, man.
I think this is such a stretch, but it's worth trying to work through the best case theory for the FCC's power to regulate. So, like Olivier says, the FCC has, in other statutory contexts, regulations that set out what it means to exercise good faith or to negotiate in good faith. So good faith is one of these terms. It's not self-defining, it's potentially ambiguous. So the FCC might be able to define what good faith means. Well, how could that be, right? How could the FCC define what good faith means if 230 doesn't say anything about the FCC's power to administer that section in particular? Well, it goes back to what Blake said earlier. There are provisions throughout the Communications Act that give the FCC the power to issue regulations as required for all the provisions in the Act. The Act being the Communications Act of 1934 as amended, and the Act as amended includes Section 230. So Congress expressly directs that 230 be inserted into the 1934 Communications Act. And so I think before we started, Olivier said you weren't going to say anything about Iowa Utilities Board. I have breached that promise. It is Iowa Utilities Board that says, look, 201 says the FCC can administer things in the Act. What the 96 Act puts things in the 34 Act, so the FCC has power over it. I think the same applies here. So the FCC has general rulemaking power over things in the Act, including 230. 230 has a number of ambiguous terms like good faith, potentially otherwise objectionable. So the FCC could issue declaratory rulings saying, here's what it means to act in good faith or to not act in good faith. Here's the sort of content that counts as otherwise objectionable that you're allowed to remove. Here's the sort of content you're not allowed to remove. I think actually the otherwise objectionable, I think there is a way to sort of limit otherwise objectionable using a sort of no-suture argument. And so, you know, if the FCC issues these declaratory rulings, then you get to the question of how is 230C2A written? It says you have no liability if you exercise good faith in removing objectionable content. So if you don't exercise good faith, or you remove content that does not satisfy the definition of objectionable, you still have to get to the question of liability. So then what are you liable for? And I guess the theory, the prevailing theory, and this is for me the hardest part. So Olivier and Blake, I'd be interested to hear what you think. But I'm just not sure what you're liable for. It sounds like the prevailing theory is breach of terms of service. And so currently the remedy for that is you can complain about it and lose your account. But I guess there's a bill, the Hawley bill would say you can get statutory damages for breaches of terms of service. So that's where the liability shield in C2A falls. Is there some other theory of liability that I'm missing?
Well, the executive order, I think that's, you said that so well, Tejas. But I will add, the executive order does identify the categories that it would associate with good faith, right? So one is, and this is where I think the executive order should have probably said nothing, but it says deceptive, pretextual, or inconsistent with providers' terms of service, which is, that last piece is, I think, what you're referring to. This question of what is pretextual, I'm not completely clear on, but deceptive sounds like something the FTC would have the authority to do anyway. But this is, again, just with regards to good faith rulemaking by the FCC. And then the second was taken after failing to provide adequate notice, reasoned explanation, or meaningful opportunity to be heard. And that doesn't resemble what I think of as good faith. That looks like something else. But so here the White House has set out what it believes good faith would entail. And even the FCC, even under Democratic, even under the Wheeler administration, the Wheeler Commission, was wary of saying, in another setting, in the Section 325 setting, about saying a lot about what negotiating in good faith is. So I don't know. I think the way you set it out is right. It's something that's inconsistent with the terms of service, presumably. I want to add one more piece to this puzzle. And Tejas, you're exactly right. We have to engage in this exercise, even if our instinct is that this is probably foolish. But the other piece is, what kind of deference would courts give an FCC declaratory order or decision about what good faith provision means? I don't think they get Skidmore deference, right? Skidmore is supposed to be the most deferential level of deference because there has to be some consistent expertise in this area. This is not something the FCC's ventured across. Now, as to whether they get Chevron deference, is something that you look to the statute about, right? And maybe it's by virtue of Section 201 that gives the FCC to implement any provision in the Communications Act. But even the agency's own interpretation of Section 230, as I think Blake, you suggested, and you do in the document you distributed, even the agency itself has disclaimed that authority. So, I don't think they did the exercise of promulgating a rule, and we should be wondering whether they have that capacity, whether it would get any deference
Yeah.
So
So
can I pick up just a couple of quick things? Tejas, your point is like so important. This is like the one thing that 230 people forget about. And I see students make this mistake all the time. This is like an exam question problem, which is if you get rid of section 230 protection, that doesn't make the thing illegal, right? Like that doesn't make the moderation illegal. The fact that C2A provides these protections for engaging in sort of says, presumptively this moderation activity is affirmatively legal. Taking that away doesn't mean it's illegal. And you know, the FCC, no matter how far it could conceivably go here, cannot like spin up a new cause of action for any of this stuff, nor can the FTC, you know, expand the bounds of what it's already been constrained with, both by Congress and Republican Congresses, by the way, and judges. I completely agree with Olivier on the deference question. I mean, we're going to get a Supreme Court that wants to, if this ever gets to the Supreme Court, that wants to dismantle the administrative state, right? We've got the major cases doctrine. We've got King versus Burwell, right? We've got non-delegation, right? Like this is going to be a real tempting case to say, like, if you want to see an agency like overreaching beyond the scope of its expertise in a way that shouldn't get deference, this is a leading contender. And by the way, like you've got now Justice Kavanaugh, who's spoken like extremely directly on this particular issue and might get some of his fellow travelers to go his way. And then just the very last thing is with what the executive order purports to tell the FCC to do, remember, it's first got to get laundered through NTIA, and NTIA has got some discretion, presumably, about what it's actually going to put in the petition. And then the FCC can completely ignore the petition, right? The FCC doesn't actually have to act on this petition. It could also like act in the absence of the petition. It could go further than the petition. It could come up with totally new ideas. It could say, you know what, all this stuff is completely pretextual and constrained by the First Amendment, and we're not going to do any of this, right? So I think the range of things that could happen at the FCC is quite broad at this point. And so we shouldn't look to the executive order to determine the scope of what's ultimately going to get sorted out here.
I'll just add one more. I know, Kate, you want to ask a question here, but I just want to add more point to Blake's excellent last point here, and that is that, so I looked again at the Massachusetts versus EPA case, just to sort out whether the FCC has to, if they get the petition from the NTIA, what the FCC has to do when they get that petition. And it's kind of basic administrative law doctrine that the agencies can enforce statutes in whichever way they want, right? The prosecutorial discretion is pretty broad. But with regards to whether they have to promulgate a rule or whether they even have to answer a petition, it depends on what the language of the statute says, right? So here there is, again, no contingency in the way that, no condition in the way that the EPA statute has a condition that the agency promulgate a rule involving 230. So they could, I think they would be on good ground to say, you know, no, we're not going to move forward on this.
So this is fantastic. I'm glad you got into the weeds, frankly. I'm not familiar with all of those cases, but I will certainly be looking them up. And that's kind of the whole point of this entire exercise, is to kind of have a smart reference point of things to go back to for people who want to do a deep dive. So thank you. I just wanted to clarify something. And this may, show where my focus is, which is always kind of on the free speech questions. But what struck me about the executive order, Tejas, is it's not just terms of service, like causes of action. You would have defamation causes of action and other types of liability as well, and class actions through that. And so I think that in that capacity, and I've been playing this out in a significant way, in that capacity, if you have something like you sue Facebook or Twitter for removing your speech because you feel like it's either not because of the terms of service, because of social media bias or whatever, or you feel like they have kept up something that was defamatory against you even when given notice, that you're going to have a very strong First Amendment presumption for the platforms to moderate their space as they want. And one that I think a wise judge or a good judge, and there's no promise of that, obviously, would basically look to Section 230 as a similar source of immunity historically to like the First Amendment and maybe continue to keep platforms immune through through their own First Amendment power. So I just wanted to kind of flag that as kind of as one more kind of complicating thing that comes out of the EO. I don't know whether that will fly with terms of service, but I do think that specifically in the world of communications torts, I think that is a very feasible thing that would come out of that. Blake, do you want to say something?
Yeah, can I ask you a question about that?
Yeah.
Can you think of any other causes of action? I think the reason we jump to terms of service is that's one that serves the president's obvious ends of wanting to keep tweets up, or to keep his tweets sort of unmoderated or unmolested. And when we think about defamation, if we get rid of Section 230, right, and the First Amendment doesn't step in a robust way, which it well might, then we're going to have platforms with a pretty strong incentive to take stuff down, which doesn't seem to serve the president's interests. Are there other causes of action for taking something down as opposed to leaving it up? Because I think most of the causes of action is like leaving something up, or it's copyright infringement, and then we get in 512.
And that's one of the things that is so kind of, when we say parse error, that like you play out the effects of what they're trying to do, or what they were trying to do, this executive order, and one, they get a world that they do not want on the internet, frankly, and two, they don't get their way. They don't get to keep up. They probably won't get to keep up their speech. And so I think that's like this piece that just has just really not like made sense to me as like we've been having this conversation. Because going back historically, as Olivier mentioned at the top of the hour, we're already in the last half hour. This went by shockingly fast. But that Olivier mentioned the top of the hour and the top of the show was that basically all of this was put up to stop pornography by conservative Republicans who are trying to bring like decency to like the web and what you have, and who had strong First Amendment, or strong, I shouldn't say First Amendment, strong free speech kind of ideals and basically, I just really think that right now, this type of, like, what's so ironic about Ted Cruz and Josh Hawley and Donald Trump and like everything else is like, they're going to get an internet this year that are filled with pornography and spam and like hate speech, or they're going to just have an internet that is full of censorship. And all of us know that those are kind of, those are the two things that Section 230 was like drafted to grapple between. But like, that seems to have been lost in this executive order, or any of in any of Hawley's drafts for amending Section 230. Olivier, do you have, I know that that's something you've contemplated.
Yeah, I mean, as you know, I do think the immunity, I don't call it an immunity. I don't read the provision that way, but I do think that the way that that there are consequences for companies if and for the internet, the distribution of content on the internet, if even a defamation claim, survives. I mean, other possible claims I thought might be a business, like a tortious interference claim for taking down, but that falls into the First Amendment defense, right? So I don't. You invited me to say something. I mean, I'm happy to hear any other people speak on this, but I mean, I am not as worried, troubled by a world in which we think of the safe harbors acting as a safe harbor. As Kate and I, you and I have been on a couple panels before, and this has come up. And the reason is just to be explicit about it, and I don't doubt Marianne mentioned it yesterday, that this is not just concern about, I mean, the First Amendment concern is also addressed to protecting historically disadvantaged groups who feel chilled from participating on, say, Twitter or something like that. But I don't know what the world looks like when these policy interventions, if they get any wind behind their sails. I'm skeptical about the Hawley bill. There's another one that will emerge very soon that is addressed more to the business model of these companies, and I think that's something that I'm far more interested in seeing. But I think I'm going a little afield here.
No, that was excellent. Tejas?
I mean, I think Olivier, what you were just saying goes back to the question of, is there a policy problem here? And if there is, what's the solution? And there may well be a policy problem here. I just don't think it's the one that the EO purports to identify. And so I think the solution is wrong.
Right.
Yeah, if there's a policy problem here, I think it's a policy problem that sounds somewhere in market power, in data protection, in perhaps unfair, deceptive behaviors via dark patterns, and the First Amendment concerns regarding historically disadvantaged groups that Olivier referred to. And none of these policy problems, none of these solutions offered by the executive order, or anything that we're talking about dreaming up as the FCC implementing or NTIA suggesting, address any of those concerns. I think the solution to those sorts of policy problems rests somewhere either in competition or direct regulation of the business model, or in regulating, really regulating unfair and deceptive practices by these consumers, by these businesses with regard to consumers' privacy interests or data interests. And that, I think that sort of policy intervention will require Congress to act. It's not something that you can do by executive order.
And I just put a quick cap on it and say, all of what Tejas and Olivier just said is evidence, I think, for the fact that this executive order is not meant to be taken literally. It's theater, right? It's like, I don't think most of the folks in the White House
theater
really,
that, as you said, wastes your time. It's going to waste everyone's time.
it's really good politics. It's really effective politics because it ties up the machinery of the bureaucracy in dealing with all of this nonsense. But it's not designed to get passed. Just like I think most of Hawley's bills are not really designed to pass. I think Hawley would be quite unhappy if suddenly the Democratic caucus came around and said, oh yes, we would love to pass this bill of yours. He would suddenly be dealing with a lot of folks in his constituency saying, hey, what are you doing, man? We're the pro-business folks. Like, we don't do this. It's a way for both Trump and Hawley and Ted Cruz and others to kind of play both sides of it. And that's why I'm always reluctant to even have these telecom law kind of discussions, because we end up spending, an hour and 7 minutes giving a lot of credit to something that is not deserving of all that much credit.
Well, I think it's important that we sum this all up. And I think that I feel like we gave a pretty, like, a 45 minutes of not talking about the EO, which was frankly, I think, really lovely, which is why I wanted to do 90 minutes, frankly, because I know that there's 45 minutes to say this stuff. And then we had to spend at least a half an hour on that. So that's where we are. Matthew Stoller has a question. I am going to bring you in to talk. Matthew, go ahead if you can unmute yourself.
Yeah, AOL and Prodigy were subscription services in 1996, so I'm interested in your view of linking Section 230 protections to behavioral advertising in some way, and this is a question about policy intervention by Congress.
Matthew, can I ask you to elaborate a little bit on what you mean by that? Like, what kind of linkage are you contemplating?
Well, removing Section 230 protections to websites or entities on the application layer that profit from Section 230, or sorry, from online behavioral advertising, which is sort of personalized, targeted advertising. That's just an idea that's been floated.
Hey, Matthew. You mentioned, I think you're mentioning two cases that 230 straddles, right? So the Prodigy case is before 230, and the AOL v. Zarin case is the first major kind of foundational case in 1997. And I'll just take on your question with regards to AOL, which was a subscription service. First of all, the court is extremely, the Fourth Circuit, Judge Wilkinson is extremely generous in his views of what the internet portends, and doesn't have in his mind, and I think most of us, I certainly didn't in 1997, envision that this business model, even as a subscription-based model, would drive the internet in the way that it has. So I don't know, I think you want us to make the connection as to that period in time. I don't think it does a lot of work, because the way in which people thought about Section 230 and the Telecom Act in the mid-90s, late 90s looks completely different because of the market now. And this is where and so I'm aligned to the extent we should be worried about 230 in that it is that intermediaries leverage the safe harbor to extract value from users in advertising markets, and in ways that, to the detriment of users, often, especially historically disadvantaged groups in the context of ads that they never see. So I completely agree, and that is on that point. But I guess I think I understand Blake's. Blake, you asked it politely. I don't think that we can tie what's happening in 1997 necessarily to what's happening now, because the market for user data looks completely different than it was envisioned at that time.
Can I pick up and say, I completely agree as a descriptive matter, right? Like, I don't think you can infer, or you can read into Section 230A. It was only meant to apply to subscription services and not to services that leverage behavioral advertising. As a descriptive matter, I think the courts have pretty much dispensed with that. The question that remains is whether you might want to do that. And I guess I would divide, do you want to do something about behavioral advertising? Is removing Section 230 protection the remedy for doing that? So I might be quite amenable and quite interested, and actually some of Hawley's bills kind of get to some of this stuff in, like, do we ban behavioral advertising, either directly or as a form of, through some kind of privacy data collection legislation? I think there's a lot of ground to till there that could be done pretty successfully. It requires grappling with the First Amendment implications of doing that in a pretty direct way. And I think there's ways to do that. And then there's also limitations the First Amendment proposes. I think people are kind of obsessed with, like, let's take away Section 230 so we can pretend that the First Amendment, like, doesn't apply to what we're going to do. And I think it's both, like, mechanically has lots of unintended consequences, and then also, like, is just going to run into these First Amendment walls later, right? Like, we're gonna look at unconstitutional conditions the same way that we would look at, just an overt behavioral regulation. So I think it's better to think about those issues separately. And as Tejas mentioned, I think, behavioral advertising is one of many places we might intervene on that. Antitrust law might be another, accessibility and cybersecurity and public safety, and there's half a dozen others we might tee up where we want to go directly regulate the platforms. But I'm not convinced it makes sense to hitch that to 230.
Yeah.
Go ahead. Go ahead. You say. I do want to respond to that, because I think we'll probably have a disagreement on a friendly disagreement. But Tejas, maybe you can.
No, I was just going to say that I think I agree with that, to say that, I agree that there are a number of policy problems that attend to behavioral advertising and the way it's implemented in a lot of these platforms. I am not sure that taking away 230 protections, if that's the right phrase, solves that policy problem. It certainly changes the incentives of the platforms in a number of ways, but I guess I would want to know more about why removing 230 liability protections affects the platform's incentive to engage in problematic forms of behavioral advertising. And I don't directly see that connection, but maybe, Olivier, that's what you were going to explain.
Well, I mean, it's speculative, because the courts have not let us do it, and
Sure.
and that's actually what my principal argument has been. I have thoughts about statutory or legislative reform, but just to be clear, before we get to congressional reform, it could be that courts are far more careful and nuanced about evaluating the extent to which the ad-based model actually materially contributes, creates, or develops content, right? That's the question. And you can be quite searching about that. Some people would not want us to think, I mean, under the doctrine, right, encouraging illicit or illegal content is not, you're still immune in that, you're still safe from immunity, from lawsuit in that sort of setting, right? The standard is pretty high. What if we took into account the ways in which Facebook targets particular, or enables advertisers to reach particular audiences, right? And that is not possible but for the material contribution of a platform like that. So courts have not been prepared to do that. The Second Circuit, as you know, was entertaining a case involving terrorism. I don't think the complaint was pled properly in the way that I would like to see it if it would be addressed to the business model, but there have been cases that Facebook has settled I think for fear that this is there's a real shot here. Now, as to legislative reform, I think I'm closer to you on the view that I don't know if it gets at the problem as well. But I'm prepared to think it might. And one is to think about the exceptions under 230.
Yeah.
Many people are worried about adding them on piecemeal. I guess I can understand that as a general matter, although we do that in all kinds of settings anyway. But what if we made an exception for violations of federal law? That is not just criminal law, not just privacy law, not just IP. That creates an incentive that's addressed to protecting that in vindicating public policy that Congress has set out, generally in furtherance of protection of historically disadvantaged groups.
Yeah, I think it's also one of the most, honestly, I think it's one of the most obvious and reasonable things, proposals to reform 230 that has been put out there, Olivier. I completely agree with that. We have Rebecca Tushnet. Nice to see you, Rebecca. Go ahead with your comment. I think it's a great one.
Hi. So I was just suggesting in the context of behavioral advertising, it's not like we're writing on a completely blank slate. There are other nations struggling with this right now. They don't have 230. And, by the way, they're not doing a hell of a lot better. So 230, to my mind, does not actually seem to be a useful tool here. So my comment was, GDPR has changed a ton of advertising behavior in Europe. And there's interesting work beginning to come out about what advertisers and advertising networks have done in response. From what I can tell, it does not actually seem to have solved these problems, although it may be doing what it's supposed to do, which is not to solve these problems. And if anything, it may be actually making the big guys bigger, since they're in the best position, basically, to comply with and make money through doing this other ways, in particular contextual advertising. So that's all.
No, it's a wonderful point. I think it's a really great point, and one that it's very frustrating when you're having this conversation about 230 it's so easy to forget this part. And I think that tomorrow, it's actually perfect foreshadowing for tomorrow, Rebecca, because the platforms and the people who have implemented policies in like the shadow of 230 will likely tell you that section 230 has had less of a consideration in how they do and how they craft their policies than you would think. But anyone want to comment on that? Olivier, do you disagree?
I do disagree. And that's because we never find out whether there is a material contribution between what websites and interactive computer services are doing and the allegations in a complaint. The Section 230 defense shuts everything down at the motion to dismiss, right? And that's a problem to me. Never mind. I mean, I'm inclined to believe that it should be hard to make that connection. I'll even go that far, but we never get to that determination. And the policy, in my mind, has to be reformed to make that possible. And one is an exception for violation of federal law. Rebecca asks a really worthwhile question. But the answer is one of the answers is another question. So what is the problem? Maybe we don't have an agreement on what the problem is. In my mind, I don't think, and I completely agree with what I think Blake and Tejas have said. The executive order, and Kate, you said this too, the executive order does not identify the right problem or provide the right solution. And what I've argued and what other people have argued, Marianne, Danielle, is that the current doctrine sets out a protection that never lets us really protect the people who are likeliest to be harmed, the people who are most worried about getting harmed. And that's the problem I'm thinking about. I don't know enough, I certainly don't know as much as Rebecca does with regards to GDPR, but we don't have an incentive structure for intermediaries to attend to that.
So Olivier, I want to pick up and say I actually really agree with both prongs of what you just said in terms of 230 cutting off at the right at the beginning of litigation a lot of problems where under federal law we might actually want to impose responsibility on platforms. So in my world, I think a lot about the Fair Housing Act. I think about the Americans with Disabilities Act, where, you know, I don't think the framers of Section 230 were intending to absolve Harvard for liability. No offense if there's anyone from Harvard on this call, but for liability for not putting videos on their website with closed captions, right? Like that's not, I don't think that was the intent of Section 230. And I'll take the Pepsi challenge on the First Amendment issues in those cases any day. We'll win the First Amendment challenges. I would also just sort of say 230 has stalled, and I think Marianne and others have teed this up, the development of First Amendment doctrine in this area, right? And so we don't know, like I've read a student note and I don't agree with it, but it's really provocative, and I'm sorry, I'm forgetting the name of who wrote it, but that says 230 is just a statutory implementation of what the First Amendment would require anyway. Right? Like that's the most extreme version of it. I think it's wrong, but I think it's a useful argument to say, how much does 230 go beyond the First Amendment? What is that overlap? And we don't have a lot of ideas about how that looks in a whole lot of areas that are relevant to internet policy because 230 just cuts off the inquiry before it gets started.
Just relating to that really quickly, Blake, I think that that's one of the reasons that I actually think that getting rid of 230 might be just, to use your kind of terminology about the executive order, for example, just a waste of time. We don't have this doctrine. We'd have to flesh it all out. It would have to grow to replace it. It just seems like recutting the cloth in like a way that I just don't think is necessary. But we have time for one more question. If we could end with Julie Cohen. I don't know if Julie is okay with being called on to speak because she hasn't responded, but I would, I'm just going to read the comment that she wrote in to Blake's comment, and then Blake, you can kind of respond to it because I think it's a good debate to kind of have on the record. She writes, simply assuming blanket First Amendment coverage for all instances of behavioral advertising and optimization for vitality is a highly problematic move. So Blake, that was mostly, I think, in response to you, Blake, but do you want to respond?
Yeah. Julie says.
Oh, virality. Sorry.
Virality.
I meant she wrote vitality. That makes a little more sense now.
Yeah, I completely agree with Julie on that. And when I brought up that there are First Amendment dimensions to all of this, I don't mean the First Amendment challenges win. I think there's all sorts of regulation that we can do of behavioral advertising, of accessibility, of housing discrimination, of antitrust law, of all the other ways that we might want to sort of regulate the platforms. I think we can do that consistent with the First Amendment and to a very great extent. And actually the FCC has a lot of experience regulating non-internet platforms to impose just these sorts of obligations and surviving First Amendment scrutiny. And I totally think we can navigate it. My only narrow point that I was making is I think people think that we are buying some latitude by, instead of regulating directly, kind of tying everything up with 230 immunity and saying, we're not requiring platforms to stop behavioral advertising. We're just going to take away their 230 immunity. I don't think that's really a different question, or not a meaningfully different question when we come to the constitutional inquiry. And so we should stop kind of, stepping on eggshells around it and just confront it. If we want to ban behavioral advertising, let's do it, and let's craft a behavioral advertising regime that's consistent with the First Amendment. I think that's eminently possible.
We have to wrap up, but I want to give everyone a chance to kind of just to kind of summarize or just kind of have a last word. Olivier, do you want to start us off?
I have so many thoughts. It's too bad that there's not enough time. I'll just say quick things. Blake, I don't think it was unreasonable to assert that there is a potential First Amendment problem in the context of advertising, not because you agree with it as a normative matter, but this court has lurched towards a doctrine that is very protective of all kinds of commercial speech. So it's not unreasonable. I would not like to see it, but that's something worth mentioning. And for what it's worth, in terms of envisioning or imagining what a ban on behavioral advertising looks like, Ramsey Woodcock has a great paper on this. It's adventurous and it takes up the First Amendment question, but it's a very assertive argument for banning them altogether, which is different from a 230 reform, admittedly, right? But it's something worth setting out. And finally, I think I just want to echo what I think everyone has said. I'm not a political scientist, but I think the executive order is pure political stunt, and the less time we spend on it, the better. But unfortunately, I'm afraid we do need to do things like this to make sure it doesn't gain any momentum.
Great, thank you so much. Tejas?
Yeah, so I guess I have lots of things to say, but let me try to focus on just a couple. So I think, one, the last bit of this conversation on the First Amendment actually brings me back in a way to some of the other policy problems, and in particular the problems of market power and concentration at this application level. And I think in part that's because, then Judge, now Justice Kavanaugh's dissenting opinion in the net neutrality case, where he finds this strange market power exception to the First Amendment, that you can regulate companies in ways that you otherwise wouldn't be able to where they have market power. I don't know that that is the right view of the First Amendment. I'm quite skeptical of it. But I think that, to the extent that this administration and the courts are going to move in that direction, that's one way to think about what sorts of regulatory power can be exercised in this space consistent with the First Amendment. And it depends, it's hinged, in fact, I think, on competition concerns. This executive order, I agree, is political theater, but it seems like political theater that has the potential to make a whole lot of administrative law and telecommunications law. And that makes me sort of nervous. It makes me really nervous. We might find out exactly what Mead means, for example. How holistic is our analysis under Mead if the FCC ends up trying to give some content to good faith or objectionable? I don't know that this is the right case to decide what Mead means, but there we are. And so I guess the last thing I'll say is there are policy problems at the application space, but the executive order doesn't identify them, and it certainly doesn't solve them. And so this is just, it was a pleasure to spend an hour and a half with you, but it's a waste of time that we have to spend an hour and a half talking about this instead of something else.
Yeah, it's
Go ahead, Blake.
Couldn't agree more. Oh, Dan Deacon says in the chat, protect Mead. Yeah, I sometimes think like the Trump presidency as a whole, and especially in this context, is like a false flag operation to get technocrats like me and Tejas to question our priors. And gosh, this sure is could be that for Mead and other aspects of ad law. I'll just say, Kate, thanks so much for hosting this conversation. And I know this telecom law, I think, to a lot of internet law people sounds boring, and sometimes it is. But I hope this conversation motivates that there's this, like, a lot of what gets discussed in internet law is kind of the tip of the iceberg, and telecom law is the rest of it floating underneath. So if there are any law students listening to this conversation that are thinking about getting into internet law, come hang out and take telecom law and chat with us, and you'll actually find, I think, a pretty rich way of applying all of the boring stuff that you learned in your leg reg or your ad law class in a way that actually underpins a lot of what happens on the internet. And so if you're interested in internet content, internet culture, come jump down the layer stack and learn about what's at the bottom. And you never know if it will lead to fun and dangerous and scary stuff like this.
Thank you so much, Blake. And guys, this was just an absolutely phenomenal 90 minutes. And I learned a lot. And even though it might have been, you might feel like a waste, I do feel like having all of these conversations, these rich conversations on the record, really, I hope does kind of create a cohesive dialogue so people are not talking past each other when they talk about 230, when they talk about regulating the internet, so that there's really like a fruitful conversation going forward. And that's kind of a long-term investment that goes beyond this executive order, and really just goes to what's inevitably going to happen, which is that these attempts to regulate the internet in this way are just not going away. Tomorrow, we're going to go jump back up the internet stack and go to what 230 meant for platforms. And we have the former general counsel at Twitter and the former head of policy at Facebook to join us. And we're going to have one more person from Google. We're not sure who that's going to be yet, but that should doubtless be a very, very interesting conversation that is very, very different than the one that we had today. And I just thank you so much and everyone for coming up, and we will see you tomorrow.
Thank you so much for having me.
Bye, guys.
Thanks, guys.